Thank you, everyone. Welcome to our May Reed Group Quarterly Compliance Update. As you know, we like to give these compliance updates about every 3 months or so to discuss what's going on in the world of leave of absence, disability, and accommodation. We will email the slide presentation and a recording of this presentation later today. If you don't get it, please let us know. We have you on mute. But if you have questions or having difficulties, please use the chat feature as you just did for the recording. And also here's our contact information if you have some follow-up questions after the webinar. I am Megan Holstein, Vice President of Compliance at Reed Group.
And I am Lori Welty. I will also be speaking today, and I'm a compliance attorney here at Reed Group.
We are missing Ashley Brennan, our third compliance attorney, because she has a baby and is home bonding. So we really take our leave of absence seriously here at Reed Group and know that Ashley's home enjoying her time with her newborn. And we do want to thank Sherry Pullen, who's also a member of our compliance team. She's a compliance analyst, and she really helped us put this webinar together on the back end. So we are your Reed Group compliance team. Lori and I are lawyers. We're not giving you legal advice, so we just want to make sure we've got that disclaimer. But what we are going to talk about today is give you a new law update and a legislative update so you can see what's pending. We're going to talk specifically about paid family leave and go through the state paid family leave, paid disability update, and focus on New York and California because those paid family leave law and changes will be effective January 1st. And then, as always, we'll go through court cases as they are discussing FMLA and ADA and pregnancy accommodation. And then we'll review Department of Labor and EEOC agency action. All right, so Lori's going to kick us off with the legislative update.
Thanks, Megan. We will start with the new D.C. paid family leave law. So this law was went into effect in early April. However, contributions don't begin until July of 2019, and benefits will begin in July of 2020. So we have a little ways to go to get ready for this one. This law applies to all employers, and what it does is it provides a payment benefit for the family, medical, and parental leave provided by the existing D.C. family leave law. So there's no new leave right here, but there is a new notice requirement that employers do need to comply with, and they need to provide that notice at the time of hiring, annually, and when they become aware that leave under one of these reasons is needed. The mayor of D.C. is tasked with issuing regulations, including a model notification form for this new law, so we will await those for further guidance. And like I mentioned, we do have some time before this law really ramps up, so we will keep an eye on that one. Georgia passed a new type of law, what we call a King Care law, requiring employers with 25 or more employees who already provide a sick leave benefit to use that sick leave for the care of certain immediate family members. And what that's going to cover is a child, a spouse, a grandchild, a grandparent, a parent, or a dependent, up to 5 calendar days per year if the employee has earned those days. Again, this law also does not require a new leave of absence, but it does expand the leave reasons for employers who opt to provide sick leave already. Vermont passed a new pregnancy accommodation law. This is going to go into effect January 1 of 2018. This law covers all employers and employees, and it requires accommodations for individuals suffering from pregnancy-related conditions. So it doesn't require a disability per se, just a pregnancy-related condition. While the law does not specifically require leave, it does require that an employer provide reasonable accommodations, which is fairly open-ended, and we know in some cases that may include a leave of absence, so we want to make you aware of that. For those situations where FMLA or Vermont family leave law has exhausted, we want to make you aware of the possibility that another leave as an accommodation might be required. And moving on to some developments in paid sick leave, we want to make you aware of some new pending regulations. Arizona, Minneapolis, and St. Paul, Minnesota, and Cook County, Illinois all have leaves that are about to go into effect on July 1, 2017. All 4 of these localities have proposed regulations for their laws that are going to go into effect on July 1. So we have links here. You can see there's some different deadlines in terms of public comments and hearings and whatnot. So when we send out this the PowerPoint, you can access those links, check those out, and see how those regulations might affect the laws if that applies to your company. Indiana signed into Indiana signed a bill into law in April that relates to a voluntary paid family and medical leave program. So the bill doesn't actually require or implement a new program, but what it does is it urges the Legislative Council to assign to their Employment and Labor Committee or another appropriate study committee the topic of establishing a voluntary paid family and medical leave program. It remains to be seen whether this is the first step towards establishing a paid family leave program in Indiana, but certainly indicates that there's some interest in that area there, so we'll keep an eye on that. The Maryland Paid Sick and Safe Leave Law is awaiting the governor's signature. The signing deadline for that law is May 30th. And Hawaii also has a law on the governor's desk. This is a law that would extend their family leave law to cover the serious health condition of an employee's sibling with a serious health condition. So that's new in terms of covered relationships. The governor has until July 11th to sign that bill into law. And then just an overview for you on the topic of proposed legislation. This shows you the type of leaves we've seen in this legislative session. You can see that sick and safe leave and paid family leave are way out in front with the most amount of new laws proposed. And pregnancy accommodation and disability and domestic violence leaves come in next. So this is pretty consistent with the laws that we've actually seen get passed. In terms of sick and safe, paid family leave, and pregnancy, for sure these are the ones that do tend to squeak through and get signed. And then we've got, of course, a whole variety of other types of leave that are also being proposed, but just less of them. And now we want to bring this into the paid family leave realm and talk about some updates. As we mentioned, or as I mentioned, and Megan also mentioned in the beginning, there's some changes to California coming up soon, and New York has a new law that's going to be going into effect July 1st. And then I mentioned January. Oh yeah, sorry about that. January 1st. Yep. And DC has got their new law coming up as well. Deductions beginning July 1st, 2019. So we thought this was a good time just to give you an overview of some of these laws. We've included in here both the paid family leave aspect and also the disability portion, so that you can see some of the similarities and differences between these laws. You'll see there's some variations in terms of leave reasons and covered relationships. A lot in common. New York covers qualifying exigency. That's the military exigency. That's different than the other laws. And then you'll notice in terms of benefits, California most generous in terms of disability. But when it comes to family care, there's a little more parity. New York is actually upping the ante. By 2021, they'll be providing 12 weeks of that family care leave. It ramps up, starting with 8 and then 10 and then finally 12. So we've got some different regulatory schemes here that the states have implemented. And then also want to mention that there are some differences in terms of whether or not these laws provide additional job protection. Some of these are freestanding leave on their own, which include a payment requirement. And then others, for example, like DC, does not have a job protection portion, but it only implements benefits for the existing family leave law in their in DC. So when we send out the PDF, you'll get all of that information that you can reference. And I'm going to turn it over to Megan to talk more in depth about California and New York updates.
Thanks, Lori. Hopefully you'll find Lori's chart really helpful to see the state laws side by side so that you can compare the various components. As we mentioned, California's statutory disability and paid family leave, which includes voluntary disability plans and voluntary paid family leave plans, is going to, the benefits are being increased effective January 1st, 2018. So currently, benefits under the disability and paid family leave equal 55% of the employee's pay, but you'll see here that that's going to increase based on a formula and depending on the employee's earnings as compared to the average earnings in California. So somebody could get between 60% and 70%. It's a little complex the calculation, and it's based on California average weekly earnings and quarterly wage earnings. I was at the California Employment Department spring meeting, California EDD. They hold a meeting twice a year for voluntary plan members, and they said that they plan on sending out more information on this calculation and recommended voluntary plan language by the end of summer. So if you're an employer who has a voluntary disability and paid family leave, we will update you when we see that the EDD has sent out more information on both the calculation and recommended plan language. If you're our client for whose voluntary plan we administer, we'll work with you to make sure your plan gets updated by January 1st. If you're an employer who does not have a voluntary plan, just know that the benefits are increasing, but your employees, of course, will file with the state, so this won't impact you as much. But what you do need to know is that for the paid family leave portion, the law also eliminates the 7-day waiting period, so an employee can receive paid family leave benefits immediately on the first day of qualifying absence. So that is the other change. So stay tuned. We will post updated information from the EDD on our blog, and if you're our client, we'll be contacting you as well to make sure that your plan language gets updated. Next, let's talk about New York paid family leave. As Lori mentioned, this is a new law that begins, benefits and the job protection begin January 1st, 2018, and it phases into a full implementation by 2021, and it will be the most generous paid family leave law out there, providing 12 weeks at 67% of a worker's salary by 2021. The state issued proposed regulations on February 22nd, and they have a website, which we have posted here, that really has a lot of detail. It's a really good state website that gives more information. The proposed regulation comment period ended. ReedGroup actually supplied comments, and we expect the final regulations by the end of next month. So by June, we should have final regulations and know exactly how to administer both the pay portion and the unpaid job protection portion of this leave. So stay tuned. Again, if you're our client, we'll be working with you. We'll also post information on our blog for everyone once the final regulations are posted. But our employer tip for you is that if you have a workforce in New York, you're currently offering disability benefits. It's called New York DBL. And paid family leave benefits have to be offered in the exact same way as your New York DBL. So if you offer it through insurance, your paid family leave benefits must be offered through the insurance plan. If you use the state insurance fund, same thing. If you're self-insured for DBL benefits, you have to self-insure your PFL benefits. So that's what you can be looking at right now while we await these final regulations, because that's the requirement as of the statute and won't change with the regulations. So something to look at until we get those regulations by the end of June. Okay, now let's move into case law. We'll start with the Americans with Disabilities Act, see what courts are thinking when it comes to the ADA and how they're interpreting that law and looking at leave as an accommodation and workplace accommodation. So we have some good ones for you this time. We'll start with the Whitaker case. Excuse me. Whitaker took several leaves of absences, and for a variety of reasons. One was allegedly due to her recurrent back pain. She took FMLA leave to care for her child. Then she took FMLA leave for her medical condition. Later, she sought leave to care for her ill father, but she had exhausted her FMLA leave, so the company offered her some unpaid time off. Then she asked for an extension of her absence for her own personal illness. And when the employer asked about this, yet another leave of absence to get more information, the doctor's note basically just said medical leave of absence until November 17th. And when they tried to get more information from her or her provider, the note came back, medical leave of absence, until December 17th. And because the employer couldn't offer any more time off, they couldn't get any more information as to why she needed time off, what her treatment plan, how this additional absence was going to get her back to work, they wound up terminating her due to the multitude of absences for the variety of reasons. They just basically couldn't hold her job open anymore. And naturally, she filed suit, as you see here. And the court basically focused on whether she was qualified to be covered under the ABA. So to me, this case is a little unique. The court didn't focus on whether providing the additional time off was a reasonable accommodation. It started at the beginning of the ABA analysis, which basically looks at the employee to make sure that they're an otherwise qualified person with a disability who can perform the essential functions with or without accommodation. And this court said the employee couldn't attend work, and the employer established that attendance was an essential function, and because she couldn't do that essential function of attending work, she was not even qualified to be covered under the ADA. So we don't often see courts looking at absence as an accommodation under the ADA, under the initial prong of whether the person is qualified, but that's what this court did. And what really helped the employer here, which is our tip to you, is the employee's job description. She had to use the department's internal computer system. She had to answer phone calls that, of course, rang into the Wisconsin Department of Health Services. She had to meet with clients who came to their office. So it was very clear that her attendance at work was necessary in order for her to fulfill her job. And so the employer established that very well through the job description. The next case, Works versus Berryhill, is nearly the same analysis as the Whitaker case. So this employee had a seizure disorder and started a new position. So she was working under the probationary period. And due to her seizure, she had to take various intermittent leave, even in her initial employment. However, also when she was at work, she was found spending a lot of time on the phone, discussing personal matters, away from her desk socializing, and basically she wasn't getting her assignments completed. So during an initial probationary performance review, she was told that there was concern about whether she can get her work done, her projects weren't getting completed, and that she was found spending time away from her desk. And there was concern that if she couldn't get her work done, that she would be terminated. Works had to take more time off for her seizure disorder, but also her socializing and personal phone calls continued, so she was eventually terminated. And of course, she filed a charge of discrimination in this lawsuit after her charge of discrimination, claiming disability discrimination and failure to provide the intermittent leave as a reasonable accommodation. But the court, much like the Whitaker court, said that she couldn't even demonstrate that she was a qualified person with a disability who could perform her essential functions with or without an accommodation, because her failure to reliably report to work contributed to her inability to complete her essential functions. So here we have two courts, this one in the Fourth Circuit and the previous one in the Seventh Circuit, focusing on somebody's attendance at work, and that if they can't come to work, that they're not even qualified to be covered under the ADA. So again, this employer's job description and the fact that her work needed to be completed at the office really helped this employer win this lawsuit. Okay. This case, my friends, is a gift to employers. We finally get a court who's going to tell us how much leave under the ADA is too much leave. This is something we've been waiting for. So if you're in the First Circuit over there on the East Coast, you know, this is a good one for you. And I think it's one that even in other circuits, employers can look to. So in this case, the employee requested 5 months a 5-month leave of absence and short-term disability benefits, which she was granted. So she exhausted her FMLA, but was given the additional time off. Before returning to work at the conclusion of her 5-month absence, she requested another 12 months leave of absence for her same condition, the depression and the anxiety. Meanwhile, while she was on her initial absence, the employer, AstraZeneca, was working on a reorganization of the sales department, which is where this employee worked. And when she came and asked for the additional time off rather than return to work, she was notified that she was being laid off as part of this department reorganization. And so, of course, she sued, as you see here. And the court said, you know what, 5 months plus 12 months continuous leave of absence is just on its face not a reasonable accommodation. Not for you, not for anyone. It's too much time. And the court said the employer didn't even have to go through the undue hardship analysis, that 17 months of leave is just facially unreasonable. So that's the gift that this court gave to us, that we know 5 months plus 12 months extension is unreasonable. In this case, the employee, the certification or the paperwork she provided the employer from her provider did not indicate what would be going on during the 12 months, how it was helping her get back to work. So I think that was part of it. But basically, you know, I think this court just thought, like, what employer can hold open a job for 17 months? Now, that's the gift. But here's our point to you as well. This employer got lucky because one of the employee's claims was that the employer failed to engage in the interactive process. So as you remember, when she asked for her extension of 12 months leave, she was handed a pink slip due to a reorganization. So they never even considered, well, is there some other accommodation we can give you, a way to get you back to work, something we can provide as a workplace accommodation. So no interactive process. But this court said, well, if the employee is requesting an unreasonable accommodation, the employer doesn't have to engage in the interactive process. But I've never heard a court say that, and I know the EEOC doesn't believe that, so I just caution employers, if you think that the employee's accommodation request is unreasonable, I wouldn't stop your analysis there and say, well, we don't have to go through the interactive process. I would still engage in the interactive process. Now, this case to me is a little bit different because of the reorganization, and the court must have found that that was legitimate, that it really was a legitimate layoff scenario too. So I think that might have played into this case as well. But here it is, 17 months continuous leave of absence is not unreasonable, is not reasonable under the ADA. Okay, moving on, we have Ortiz-Martinez. This woman injured her hand while she was working for Fresenius Health Partners, and it was a position that required her to write regularly. It was a workplace injury. She was on leave for that injury for 11 months, and then she was cleared to return to work with, quote-unquote, necessary adjustments. And the employer said, okay, well, what are the adjustments? What do you need? And neither the employee nor her provider responded to multiple attempts to get this information. So the employer didn't return her to work and eventually let her go because they couldn't find out what kind of accommodation she needed, but her job involved writing. And so, of course, she filed suit as a result of the termination. But the court found in favor of the employer and said, look, employee, you're obligated to engage in the interactive process. You have to participate. You can't just turn in a note that is vague and unclear and not provide any more guidance to your employer. So make sure that, as an employer, if you're engaging in the interactive process, we recommend that you document it and you try and try again because eventually, when your hands are tied and you don't know how to accommodate your employee, you have the evidence to defend yourself in the lawsuit. Okay, this case is a little unusual because the court here focused solely on whether the employee had a disability. So in Alston versus Park Pleasant, the employee was placed on a performance improvement plan. She had a new supervisor. She didn't get along with the supervisor, allegedly. Her performance declined. So she was placed on a PIP, and then after that, she was diagnosed with a form of breast cancer. And, her performance issues persisted, and eventually she was terminated. And, of course, she filed suit. But the court did something that we haven't seen recently in ADA cases. So when the ADA regulations were updated in 2011, as you all know, both Congress and the EEOC said, employers, you need not focus so much on whether the employee has a disability and heavily litigate the disability. What we want you employers to focus on is finding an accommodation and engaging in the interactive process. Well, this court focused on whether or not this employee had a disability. And the surprising thing is that the disability was breast cancer, and as you probably know, under the ADA, cancer is one of those conditions that's pretty much guaranteed to be a disability under the ADA. It's listed as one of the, like, almost always will be a disability because cancer limits a major life function of cell reproduction. However, this court said they're not going to agree that this early stage breast cancer automatically was covered by the ADA because she didn't prove that her cell functioning was limited. I think it didn't help that both in her deposition testimony and her lawyer's argument, court arguments, said that she had no limitations, that she could work, this cancer didn't inhibit her ability to work. So I think that evidence wasn't helpful, but it is surprising to see a court treat a cancer condition this way. So we bring this case to you, not necessarily because we think you should be disputing cancer conditions, but really just to emphasize two things. First, the courts can be extremely unpredictable. This was a surprise to me, the way the court addressed cancer under the ADA, but more so proof that you have to do an individualized assessment and to make sure that you're documenting it. And don't simply disregard that, the disability analysis under ADA. So you want to make sure that you've covered that the person is disabled and then that you move into the interactive process after that. Okay, here we have Paxton, where again, the court focused on whether the employee had a disability. So I'm kind of surprised to see courts moving back to the pre-2011 regs, the pre-2009 ADA amendments, and going back to focus on a disability. So, you know, it's kind of proof that not every condition is going to be an ADA-covered condition, and employers don't need to just you know, disregard that step in the ADA analysis. So Paxton, in this instance, had surgeries in her childhood for cleft lip and cleft palate, and she had 3 surgeries in the 50s for the cleft lip and palate. And she alleged that because of these surgeries or because of her cleft lip and palate, she often got sinus infections. And because she has this history of sinus infections, she had requested to work in an enclosed office space away from drafts and the draftiness of the office and the HVAC system. So her employer said, okay, fine, they gave her an office space. Well, the employer was bought out by the defendant, and as you know what happens in M&A activity, there's a reorganization, so she got new responsibilities, and her new employer, the now defendant, determined that she should be working in the open space area at a desk closer to her coworkers based on her new duties. But they went through in the office and found a desk that had very low air movement away from the vents. They did some pretty elaborate testing and assigned her to a desk that should suit her concerns about her frequent sinus infections. However, she refused to move from her office, and she got very, very upset, and she said, I'm leaving, and was told, don't you leave, or, you know, you'll be fired, or something like that. Well, she left, and she was terminated. So she brought suit. However, the court again said, you know what, you don't have a disability under the ADA. Your childhood cleft lip and palate has been surgically repaired, and you've not produced any medical evidence that the cleft lip and palate are causing your frequent sinus infections, that there's, you know, there's no disability here. So the court dismissed her claim for disability discrimination and failure to provide an accommodation. However, the court did not dismiss her claim of retaliation. So as you'll recall, she was basically fired because she walked out when she was told that she won't get her accommodation of the office space. So, you know, she was complaining and moaning and groaning about her disability and her the employer's inability to give her her requested accommodation, and fired her when she walked out because of it. So the court said, yep, this claim can proceed to trial because there is a chance that she was retaliated against because of her complaints under the ADA. So our tip to you is even if an employee isn't ultimately covered under the discrimination law, here the ADA, an employee's actions and behavior may be covered if, an employer may still be liable for retaliation against an employee who's bringing up issues under a discrimination law, even if they aren't ultimately covered by that discrimination law. So retaliation remains a viable claim even though the employee wasn't covered, her condition wasn't a covered disability. Okay, a couple more ADA cases. Under Bush v. Compass Group, the plaintiff was a chef manager at Compass Group. So Compass Group provides cafes and catering to large office complexes and large businesses. This person worked at a company, the Kentucky Farm Bureau business, and ran the office cafe and ran the catering. So as you can imagine, as managing chef, he had to lift more than 10 pounds and often up to 50 pounds, lifting bags of potato and flour and catering trays and things like that. So he had a back condition that was getting worse and worse, and he knew that he couldn't do the job because of this back condition and all the lifting. So he applied for 10 positions, open positions at Compass Group, 9 of which would have been a promotion, 1 of which would have been a lateral move. And in the meantime, he started hiring temp staff to help with the catering events and help with the lifting. Eventually, he obviously didn't get hired for one of the 10 positions, and then was eventually let go because he couldn't perform the essential functions, which included a lot of lifting and carrying of the heavy food items. So he brought suit, and the court said, the employer argued that, the lifting and carrying was essential job function, and it couldn't accommodate him by hiring temp staff, and that Bush, the plaintiff, said that the employer also should have transferred him as a reasonable accommodation. But the employer said, no, the transfers were promotions and he wasn't qualified, and an employer is not required to put somebody in a position they're not qualified for, which the court agreed and said that's not reasonable to ask an employer to promote somebody when they're not qualified. That's not a transfer under the ADA. And for the one position that was a lateral move, Bush did not go through the right process, the internal process for the lateral move, and so the court said that the employer does not have to waive their internal rules and policies as an accommodation, and nor does the employer have to hire temporary staff to perform essential functions that an employee can't perform. So the claims did not go forward and were dismissed. In this case, again, job descriptions were really helpful, but this court also focused on not only the job description, but testimony from employees that talked about the lifting and carrying of the catering job and that occurred in the kitchen at the cafe. So as you're focusing on your written job descriptions, you've seen 3 cases here that the court has focused and used as evidence job descriptions. Make sure, of course, that the job descriptions actually match what employees are doing, because they may be testifying and providing additional evidence in an inevitable lawsuit. Okay, our final ADA case, we have Wagner. And this guy had many incidences where he had violent outbursts, screaming at coworkers, which of course shouldn't be tolerated in the workplace. So he was suspended for he had 3 outbursts. And as he was going through this suspension meeting and this last chance agreement that he would have to be under when he returned from his suspension, he disclosed that he had bipolar disorder and that he was going to go get help. And his supervisor said, that's great, we'll see you when you get back from your suspension. So he comes back to work, things are fine. He applies, bids for a few other positions at the work site, didn't get those jobs. So in bidding, he never said that he was looking for a transfer as a reasonable accommodation due to his bipolar disorder. He simply just went through the bidding process like any other employee. Well, then he had a final outburst, his 4th one, He was threatened an employee, used threatening language, and of course was fired under the company's policy of prohibiting abusive and threatening behavior at work. And Wagner still brought this lawsuit claiming that he was not accommodated, not transferred due to his condition. But the court said, no employee, you have to actually request the accommodation, and simply bidding on other positions and applying for other positions at work is not a clear request for accommodation if you don't tell the employer why you're bidding on those jobs. They'll simply treat it as, you employee looking to fill an open position at work. So just remember, employees have some duties under the ADA, specifically to request an accommodation and also to engage in the interactive process. However, make sure you know what a request looks and sounds like, because an employee doesn't have to use the word ADA or accommodation or disability, but they do have to somehow request it. It's not just applying for an open position makes it obvious that it's an accommodation request. All right, now Lori's going to talk to us about cases that talk about both FMLA and ADA and our FMLA case law.
Thanks, Megan. So Acker and Moss, the first two cases I'm going to talk about, really get at the distinction between the objectives of a leave in the FMLA and the ADA. So kind of an interesting analysis in those cases, because it really shows how the court will treat those requests for leave differently depending on what type of leave is being requested. But I want to start with the Acker case that starts out with an analysis of an employer's ability to enforce their notice policies. So here in Acker, the employee called the company absence line, but not the benefits and service line. So that was two different lines the employer had. The company policy required that the employee call both the company absence line and their benefits line that was administered through a PPA. The FMLA allows an employee or an employer to enforce their usual and customary procedures for requesting FMLA leave unless there's unusual circumstances. And in this case, the plaintiff didn't demonstrate that there were any unusual circumstances arising from his condition that would have prevented him from complying with their call-in policy. So employer tip here is that courts will enforce these attendance call-in policies when they are clearly communicated and also enforced. The other interesting analysis in the Acker case relates to the ADA. So another argument the plaintiff made is that the company failed to accommodate his disability by not providing FMLA leave. So he argued that his request for FMLA leave in and of itself sufficed as a request for an ADA accommodation. But the court noted that the request for FMLA leave is not alone a request for a reasonable accommodation under the ADA because the laws have divergent aims. And the court reminded us that the FMLA is for when an employee is unable to perform the job, while the ADA is specifically geared for when the employee can do the job but needs a reasonable accommodation, which may include leave to get them to that point. While the court was pretty definitive on this, we also want to caution employers to be watchful for those situations where FMLA exhausts and the employee is still unable to return to work, as that could trigger some obligations to engage in the interactive process under the ADA. And that leads us into the Moss case. So in Moss, the employee's FMLA leave exhausted, and he sought an additional 6 months of leave under the ADA. But in this case, that 6 months of leave would bring him to his retirement date. So his intention was to take his ADA leave and then not return. So it wasn't geared towards enabling him to perform the essential functions of his job, because the whole point was really to enable him to reach the finish line to retire. So the court held that taking leave without the intention of returning to work is not a reasonable accommodation under the ADA. And now I'm going to shift gears just into straight FMLA cases. This case here, the Marshall versus Rollins Company case, considers the sometimes hidden motivations for employment decisions and how sometimes a court will dig into that in determining a motivation. Here, the employee took leave and upon her return was demoted by the division's president. And while the president made the decision not to, or to demote her, not as a result of her FMLA, there was no evidence that he specifically was trying to discriminate against her based on her leave. He did rely upon the recommendations of the vice president, who may have been motivated by her prior FMLA leave. The court found that if the president was sufficiently influenced by the vice president, then the company could be liable under what is known as the cat's paw theory of liability. The court also noted that because an organizational chart doesn't always reflect accurately how decisions are made, a lower-ranking employee can have influence over a decision-maker who may not be involved in the day-to-day operations of a company. The key takeaway here is to ensure that in addition to ensuring that your supervisors are not taking FMLA leave into account in hiring and firing decisions, that a supervisor is making a decision based on truly independent factors and not relying on feedback that might be coming from a biased source. In both the Egan and Stewart cases, which I'm going to talk about next, we have courts recognizing that if an employee is able to show that their FMLA leave might have factored into a termination decision, even in a small part, they may have a claim there for retaliation. In Egan, the court found that the employee can pursue an FMLA retaliation claim under a mixed motive theory. So the lower court in Egan had denied the jury instruction for a mixed motive, but the district court held that the employer cannot consider the use of leave as even a negative factor in an employment decision, even if mixed in with several other legitimate factors. And similarly in Stewart, the employee here was well off track from her performance goals, and alone would have certainly been enough justification for her termination. But unfortunately, in the email recommending her termination, the manager stated, in addition to providing a laundry list of clear performance issues, that her termination, quote, was justified because she submitted a request for medical leave. I know we're all cringing when we hear that. These, unnecessary comments in emails can really trip up employers. So employer tip here is pretty obvious. FMLA leave cannot factor into employment decisions. And if you have an employee who you need to terminate for performance issues, keep the leave out of it entirely. Here in John D., we look at the issue of situations where an employee becomes eligible for FMLA leave sometime midway through the leave they are requesting. And here we have the court recognizing that even if the employee is not eligible for FMLA leave at the time of the request, or even at the time the leave is to begin, if the leave covers a period of time where sometime during the leave the employee becomes eligible, an employee's request for leave could trigger FMLA protections. So an employee who notifies or requests a leave that may extend into a period of time where they are eligible, they are entitled to FMLA protected leave for that period of eligibility. So any adverse treatment based on a leave request could be grounds for the employee to claim interference. And in the case at hand, the court wasn't so sure that the employee actually demonstrated that the FMLA would have applied to a portion of the leave because the claim didn't specify whether the leave would have extended into that FMLA eligibility date. So the court did dismiss the claim, but it left open the possibility that the employee could refile with more facts that might support that claim. Now, moving on to the Jones versus Gulf Coast case. First, there's two pretty different topics that were addressed in this case. I want to mention the temporal proximity part of it. This is sort of a technical issue, but something that does come up from time to time. When a court will look at an adverse employment decision and has to determine whether it was close enough in time for the leave to be considered, for the negative employment action to be considered circumstantial evidence that the leave factored into that decision. And so the court looked at how that temporal proximity is measured. Is it measured from the date the employee began the leave, or is it measured from the date the leave ended? And what the court concluded that it is measured from the last day of FMLA leave until the date of the adverse employment action. So if there is a proximity between the last day of leave and the date that the adverse employment action occurred, that could be considered circumstantial evidence that the leave factored into that adverse employment action. But moving on to the meat of the case, this case and the next case I'm going to talk about on the next slide reflect the importance of employers setting forth clear and uniformly enforced employment policies. If this case sounds familiar, it's because we did talk about this case before last summer when the district court looked at it. If you recall, the employee had exhausted FMLA leave, and afterwards he requested and took an additional month of non-FMLA leave to further recover. During that time, he took a vacation and posted some pictures on Facebook of the vacation. Shortly after that, the employer terminated him. The district court dismissed the plaintiff's case, holding that there was no evidence that the leave itself factored into its termination, and there was some testimony at the time that the employer's social media policy which prohibited social media usage that would adversely affect a fellow employee's job performance, factored into the termination. But the 11th Circuit looked at the case again and looked at whether or not the employer's alleged reasons for terminating him, the violation of a social media policy, were pretextual. So whether or not they were hiding the fact that the real reason he was being terminated was his FMLA usage. His employer had told him that he was terminated because he took a vacation while on leave that they found out about through Facebook, but the employer actually didn't have a policy prohibiting a vacation during leave, and the social media policy, the court found, didn't specifically apply to his behavior because posting vacation pictures on Facebook really didn't adversely impact his fellow employees' job performance. So the court concluded that his behavior of posting pictures from his vacation didn't actually violate the terms of the policy. And on top of that, he wasn't told that that he was being terminated for violation of the social media policy at the time of his termination. He was told rather it was the vacation he took that was the main reason. So we have a couple takeaways here. First of all, if you don't want your employees taking vacation during leave, make sure you put that in the employment policy. And also be clear about decisions for employment actions. Providing a reason at the time of termination and then later providing a different reason is going to be a real red flag for courts to consider that to be pretextual. Now, on the flip side, the Norris case here continues with the theme of the importance of clearly articulated and enforced employment policies, but it shows the opposite, where an employer clearly articulates the policy and consistently and uniformly enforces it. So in this case, the employee was on an approved medical leave, but ended up being incarcerated during part of that leave. The employer terminated him for improperly using medical leave to excuse his incarceration absences. But the employee argued that he would have been absent anyway and he wasn't scheduled to work, and there is some logic to that. However, the court was persuaded by two key factors. One, the company actually had a policy that the employee could not use medical leave for absences due to incarceration, and secondly, the company had fired 12 other employees for this very same reason. So here we see that courts love these clearly articulated and enforced policies and will uphold decisions based on those. Now we're going to move into the topic of pregnancy accommodation cases where employees who are pregnant are seeking leave or an accommodation. So here, the employee, a certified nursing assistant in the LeCount versus South Lewis case, was approximately 13 weeks pregnant. She gave her employer a doctor's note restricting her from lifting more than 25 pounds, and she was placed on medical leave. When her leave exhausted, she was terminated, and she sued, arguing that claiming disability and pregnancy discrimination under federal and state law. The court dismissed her ADA claim and stated that she hadn't alleged that she was pregnant and that she had a related mental or physical impairment. Her argument was that she was pregnant and her doctor imposed a lifting restriction, but she didn't claim that she had an abnormal or high-risk pregnancy. So this case reminds us that pregnancy alone without a related mental or physical impairment is not an ADA disability, even with a lifting restriction. Limitations must result from a pregnancy-related condition that constitutes a disability, or it must result from the interaction of the pregnancy and an underlying condition that constitutes a disability. But we want to remind you to consider all applicable laws. While pregnancy alone is not a disability, when it comes to pregnancy, there is a complicated network of laws that apply depending on the state that your employee is in. And there may be a state pregnancy accommodation laws that apply, such as the Vermont law that we mentioned earlier in this webinar. We also want to remind you that in our last webinar, we provided a chart that analyzed the various state pregnancy laws, including those accommodation laws that may apply to those employees who do not have a disability but are affected by pregnancy. Now we're going to move into agency action, and Megan is going to mention the latest developments there.
Thank you. If you want to access our February webinar that has the pregnancy accommodation laws state by state, just go to ReedGroup.com, and under the resource tab, you'll find the presentation from February's webinar where you can get Lori's super handy chart of state pregnancy accommodation laws. Okay, moving on to agency action to conclude our webinar. The Department of Labor has been pretty quiet the last 3 months, and I think it's largely because they haven't had a Secretary of Labor. But on April 28th, Alex Acosta was sworn in as our new U.S. Department of Labor Secretary. This is not his first presidential appointment. As you can see here, he served on the National Labor Relations Board, and he's been Attorney General and U.S. Attorney before. Other than this, we've not heard anything else from the Department of Labor that impacts disability. So nothing from the FMLA branch, nothing more on ERISA. If you attended our February webinar, you know we covered the upcoming ERISA regulations that will go into effect January 1st, 2018. So there are some changes on the horizon, but just nothing in the last 3 months. We will have more updates on the ERISA changes, probably in our fall webinar, to make sure that you're ready for those. The EEOC, on the other hand, has not slowed down. Acting Commissioner Lipnick was given her title right at the beginning of Trump's administration, so I think that allowed for a smooth transition because she's been on the EEOC for a while, and moving into the acting chair position, I think, was a pretty seamless move. So what we have here are a bunch of ADA settlements from the EEOC. So as a reminder, the EEOC enforces the ADA, and the Department of Labor enforces the FMLA and ERISA. So that's why we talk about both agencies. So we've got a bunch of consent decrees and settlements. It's kind of the same story, the EEOC going after employers who just won't engage in the interactive process. So for instance, the Zale, Delaware, they run those piercing pagoda jewelry kiosks at the mall. They had an employee who returned from leave. She has a degenerative disc disease, and she asked to sit for 15 minutes of every hour on a stool at the jewelry kiosk, and rather than give her the stool, they fired her. So to me, seems like in a very expensive way to handle a request. A stool is probably like $15, but instead they paid $30,000. So, and you'll see IDEX, they have somebody they fired because they were worried that he couldn't do his job because of his cancer treatment. They constantly were bothering him about his illness and questioning whether he could do his job during his treatment. So, you know, honestly, it's better to just work with the employee to see what kind of accommodation you can provide them as they are treating their disability. Here are some other settlements that are, you know, not insignificant dollars. So same old, you have, you know, the Valley Life Company who has a policy of firing people as soon as they exhaust their short-term disability or FMLA leave. They clearly haven't attended our webinars over the past 2 years or read our white paper that tell you employers that you can't have a hard and fast rule to fire somebody. You have to consider ADA leave, at least go through the interactive process, both for leave as an accommodation and as you can see here, for workplace accommodations as well. This one is for you HR folks and the lawyers out there. You know, you've been busy attending webinars, trying to make sure your policies comply with these EEOC consent decrees, trying to keep your companies out of trouble, and doing the best you can to comply with the ADA and FMLA. Even though the EEOC probably drives you nuts and you find that it's onerous, they have your back too. As you can see here, the American Dental Association fired their chief legal counsel and director of HR because they told the board of directors about potential violations under the FMLA and other anti-discrimination laws. So, you know, the EEOC is here to protect you as well as you're trying to keep your company out of trouble with them. So, you know, basically, I'm sort of saying this in jest, but it's true that, you know, if somebody is complaining about discrimination laws and potential violations of the ADA, the answer is not to fire them. That is considered retaliation. And then this was a significant settlement, Magnolia Health Corporation with the EEOC. So we just want to point out what happens with these settlements and consent decrees. That not only do you pay a lot of money as a company, but you often have to retain and hire and retain a consultant to revise your policies, conduct training. You're going to have to maintain a centralized system to attract accommodation requests, which ReedGroup would argue you should do anyway. And the EEOC is going to monitor you and require reporting. So it's onerous to get into the focus of the EEOC, even if they do have your back as a lawyer or HR person. So we, of course, recommend that you do this ahead of time. And, of course, ReedGroup offers our LeadPro software as a centralized system to track accommodation requests, among other things. And then we also have our outsourced solution to handle the interactive process and take that burden off of you. Other resources we provide, including these webinars, are our blog, which you could subscribe to at any point at reedgroup.com/blog. We have our Leave Advisor content knowledge tool, which is the 50 state and federal leave laws. It also includes municipal and county leave laws, so those city paid sick leave laws that we are seeing enacted. And we monitor pending legislation, and you can too if you use Leave Advisor. And then we have our MD guidelines, which is our durational disability return to work guidelines. So we're right at time. We want to thank you for attending our webinar. The deck is coming out to you as well as a recording. It has our contact information if you have questions. We thank you for attending, and we look forward to our next one in about 3 months. Have a great day.